major ruling involving the Second Amendment.
Major decision from the Supreme Court that could have larger implications on gun laws nationwide.
In a 6-3 decision, the court struck down New York's law, which places restrictions on concealed handguns.
There is a difference between states deciding how they want to regulate any number of things versus stripping people of their rights to self-defense.
Will allow scrutiny for all gun laws pertaining to everything: assault weapons, age restrictions, restrictions on magazines.
A single Supreme Court decision just unleashed a legal earthquake that's shattering gun control laws across America faster than anyone predicted. 6 justices voted to create a constitutional test so radical that federal judges are now forced to become historians, digging through centuries-old documents to decide whether modern gun laws can survive. The result? Over 3,000 court cases flooding the system, with judges striking down firearms regulations at a rate that would have been unthinkable just 2 years ago. What started as a challenge to New York's concealed carry permits has morphed into something far more powerful. The ripple effects are hitting 157 million Americans across 8 states, forcing emergency rewrites of laws that stood for over a century. But here's where it gets even more intense. This is just the beginning of a constitutional revolution that's accelerating beyond anyone's control. The moment everything changed happened on June 23, 2022. The Supreme Court handed down New York State Rifle and Pistol Association versus Bruen, and with it, Justice Clarence Thomas delivered a 63-page opinion that would become the most significant Second Amendment ruling since District of Columbia versus Heller 14 years earlier. But unlike Heller, which simply recognized an individual right to bear arms, Bruen went nuclear on how courts evaluate every single gun law in existence. Thomas wasn't alone in this seismic shift. Chief Justice John Roberts joined him, along with Justices Samuel Alito, Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett. Together, these 6 conservative justices formed a supermajority that didn't just strike down one law. They rewrote the entire playbook for how American courts analyze firearms regulations. The old system had worked like this. When someone challenged a gun law, judges would weigh public safety concerns against Second Amendment rights using something called intermediate scrutiny. This balanced approach had upheld most gun control measures for the 14 years following Heller. Courts could consider modern realities like crime statistics, technological advances in firearms, and contemporary public safety needs. That entire framework? Thomas threw it straight into the constitutional trash can. The new test he created sounds simple, but its implications are staggering. From now on, judges can only uphold gun restrictions if the government proves similar regulations existed during America's founding era or Reconstruction period. Modern concerns about mass shootings, advances in weapon technology, urban crime rates, none of that matters anymore under Bruen. Only dusty historical documents from the 1700s and 1800s count. This radical shift hit 8 states like a constitutional sledgehammer: New York, California, New Jersey, Massachusetts, Maryland, Hawaii, Rhode Island, and the District of Columbia, all operated under what's called may-issue concealed carry systems. Under these laws, licensing officials had broad discretion to deny permit applications, often requiring citizens to prove proper cause or demonstrate a special need beyond general self-defense to carry a firearm in public. These weren't minor jurisdictions we're talking about. Combined, they represented 157 million people, nearly half the entire United States population living under restrictive gun licensing that the Supreme Court had just declared unconstitutional in one sweeping decision. The scramble that followed was unprecedented. Within 48 hours of Bruen, attorneys general across these states issued emergency legal opinions completely reversing decades of established practice. New Jersey's Attorney General Matthew Platkin directed law enforcement to immediately stop enforcing proper cause requirements. Officers who had been denying permits for years suddenly had to start processing applications on a shall-issue basis, meaning if someone met basic requirements, they got their permit, period. California and Hawaii issued nearly identical emergency directives. The century-old may-issue system that had defined gun regulation in these states vanished overnight, replaced by a constitutional mandate that turned discretionary denials into violations of fundamental rights. The numbers revealed just how dramatic this shift became. New York City Police Department statistics from September 2022 showed something extraordinary. Concealed carry permit applications submitted between June 23rd and August 31st accounted for nearly 50% of all handgun permit applications received during the entire year. Think about that. In just over 2 months, the NYPD received half the applications they'd normally see in 12 months. This massive surge came from citizens who had been denied permits for years under the old standard, suddenly gaining constitutional protection to carry firearms in public. Maryland suspended its proper cause requirement just 2 weeks after Bruen. State after state with may-issue systems scrambled to rewrite statutes, knowing that failure to comply meant certain defeat in federal court. But the concealed carry revolution was just the opening salvo. Bruen's new historical test became a weapon that gun rights activists and Second Amendment organizations wielded against virtually every firearms regulation on the books. The scale of this legal assault defies belief. The Trace, a gun policy research organization, compiled data revealing that federal courts have ruled on nearly 3,000 Bruen-based challenges since June 2022. To put that in perspective, that's more than double the approximately 1,000 cases filed in the entire 14-year period between Heller and Bruen. The legal system is drowning in Second Amendment challenges, and judges are striking down gun restrictions at rates that would have seemed impossible under the old framework. The list of laws falling to Bruen challenges reads like a comprehensive catalog of American gun control efforts. Federal courts have declared unconstitutional assault weapon bans in California and Illinois that had stood for decades, prohibitions on carrying guns in mass transit systems that cities relied on for public safety, restrictions on firearms in federal buildings like post offices, bans on guns with obliterated serial numbers that law enforcement used to trace weapons, age restrictions preventing 18 to 20-year-olds from purchasing handguns, ghost gun regulations requiring serial numbers on privately manufactured firearms, and even red flag laws allowing temporary firearm removal from individuals deemed dangerous. The Fifth Circuit Court of Appeals delivered a particularly shocking ruling in January 2025, declaring that federal age restrictions on handgun sales violate the Second Amendment. This means gun stores in Texas, Louisiana, and Mississippi can now legally sell pistols to teenagers. A federal district judge in Mississippi went even further, striking down portions of the federal machine gun ban using Bruen's historical analysis. Federal courts in New York declared significant portions of the state's hastily enacted post-Bruen sensitive places restrictions unconstitutional, creating a patchwork of confusion about where guns can and cannot be carried. The legal chaos is spreading faster than legislatures can respond, creating a constantly shifting landscape of gun rights and restrictions. The fundamental problem with Bruen's historical test becomes clear when you watch judges try to apply it. Justice Ketanji Brown Jackson, in her dissent to a later case, criticized Bruen for forcing judges into service as amateur historians without proper training or resources. She wasn't exaggerating the problem. Federal judges have now issued over 1,000 opinions requiring historical comparisons between modern gun laws and regulations from the 18th or 19th centuries. The results are a judicial mess of epic proportions. Courts examining identical laws reach opposite conclusions depending on which historical sources they find persuasive and how they interpret centuries-old statutes. Two judges analyzing the same historical evidence about militia laws, permitting requirements, or sensitive places restrictions routinely come to completely contradictory findings. One judge might find that a colonial-era law about storing gunpowder safely justifies modern ammunition restrictions, while another judge examining the same historical record declares such comparisons invalid. Constitutional law professor Eric Rubin at Georgia State University didn't mince words about the chaos. There are 1,000 decisions going in all directions because history is not reliable in the hands of qualified historians, much less in the hands of unqualified historians. None of them should be doing history in any meaningful sense of the word. The Supreme Court essentially created a constitutional test that federal district judges lack the expertise to apply consistently. The result? Unpredictable outcomes, endless appeals, and a Second Amendment jurisprudence that changes depending on which judge happens to hear your case. The casualties of Bruen continue mounting daily. Federal courts have already struck down laws that seemed bulletproof under the old framework. Prohibitions on felons possessing firearms in certain circumstances, gone. Bans on gun ownership for individuals with domestic violence restraining orders, struck down before the Rahimi case, partially reversed this trend. Age restrictions preventing 18 to 20-year-olds from buying handguns, unconstitutional. Restrictions on marijuana users possessing firearms, invalidated. Large capacity magazine bans limiting ammunition to 10 rounds fell across multiple jurisdictions. Assault weapon prohibitions targeting AR-15 style rifles crumbled under historical analysis. Concealed carry restrictions in numerous locations previously considered sensitive, public transit, parks, government buildings, declared unconstitutional. Ghost gun regulations requiring serial numbers on privately manufactured firearms couldn't survive Bruen scrutiny. Even waiting periods for handgun purchases in several states fell to constitutional challenges. The Seventh Circuit's decision striking down Illinois' assault weapon ban sent shockwaves through gun control advocacy groups. The Ninth Circuit, traditionally seen as friendly to gun regulations, invalidated Hawaii's ban on butterfly knives and later switchblades using Bruen's historical methodology. When even the Ninth Circuit is striking down weapon bans, you know the legal landscape has fundamentally shifted. What we're witnessing isn't just a series of court decisions, it's a constitutional revolution in real time. Bruen represents the single largest expansion of gun rights in modern American history, and the revolution shows no signs of slowing down. The Supreme Court's conservative six-justice supermajority appears committed to this aggressive Second Amendment interpretation, with more cases working their way up through the system. Lower federal courts continue striking down gun laws at unprecedented rates, emboldened by Bruen's historical test. Gun rights organizations have filed hundreds of additional lawsuits challenging regulations that survived constitutional scrutiny for decades. They're systematically targeting every significant federal, state, and local firearms regulation, using Bruen as their constitutional battering ram, and they're winning at rates that would have been impossible under the pre-Bruen framework. The firearms industry is responding to this new reality, with expanded product lines targeting newly legal markets. Concealed carry permit applications have surged in formerly restrictive states. Gun sales spiked following Bruen as citizens in May-issue jurisdictions who were previously denied carry rights rushed to exercise newly recognized constitutional protections. Legal experts predict the Supreme Court will be forced to take additional Second Amendment cases as circuit courts issue conflicting rulings on age restrictions, felon prohibitions, assault weapon bans, and sensitive places designations. Given the court's 6-3 conservative majority and Justice Thomas's expansive Second Amendment philosophy, more gun laws face elimination. The Bruen framework fundamentally shifted constitutional power away from legislators trying to enact public safety regulations and toward judges conducting historical analysis that frequently invalidates modern gun control efforts. This isn't just about guns, it's about how we interpret our Constitution and whether 21st century problems require 18th century solutions. The Supreme Court's 6-3 Bruen decision triggered the largest expansion of gun rights in American history, forcing 8 states to rewrite their laws overnight, generating 3,000 federal court challenges and putting every modern firearms regulation in constitutional jeopardy. Federal judges are striking down gun laws at unprecedented rates using a historical test that legal experts say cannot be consistently applied. The question facing America is whether Bruen is protecting fundamental Second Amendment rights or creating dangerous chaos in gun regulation that puts public safety at risk. That's it for today, folks. See you in the next video.